Individual rights under the United States Constitution. Ideological conflicts between the Federalists and the Anti-Federalists threatened the ratification of the Constitution. So the Bill of Rights was proposed by James Madison as a method of protecting the basic principles of human liberty. The bill was designed to protect the individual against the oppressive powers of the federal government. As enacted, the Bill of Rights provided the solution necessary to ratify the Constitution, but did not protect the individual's liberty from all forms of state power. Individuals had rights, but they were not effective against state and local government forces. Following the Civil War and the ratification of the 14th Amendment protecting individuals from the state's taking of life, liberty, or property without due process of law, the Bill of Rights could be used to provide individual protections against the state, as well as against the federal government. The Bill of Rights was designed to protect individual liberties from oppression of the state. It provides protection for individuals against state action, action of a party or individual that's acting on behalf of a governmental body. The Bill of Rights does not protect individuals from other individuals, corporations, or other private parties. So, an individual restricted from speaking by police representing the government is able to invoke his or her right to free speech. However, that individual is unable to invoke constitutional rights against a corporation restricting speech on its own premises. The constitutional rights of individuals are restricted to state action. There's one exception. The 13th Amendment prohibits slavery, and it applies to private parties as well as those of the state. An individual forced into slavery by another individual or a company is able to invoke 13th Amendment rights against the private party. State functions can be privatized, and the line between private and state actors can become somewhat blurred. For example, a government body could privatize the running of prisons, delegating the responsibility to private firms. The management of voting could be handed to private companies. Delegating state functions to private firms does not eliminate the individual's fundamental rights, and the Supreme Court has held private citizens to be liable as state actors when they run prisons, operate their own private municipalities, or conspire with government officials to deprive people of their rights. Private parties running public functions like prisons that are traditionally and exclusively performed by government are considered state actors. So are those acting under direction or command of the government, or those joint venturing with the government. However, merely regulating or licensing a private activity does not constitute state action. Even before the Bill of Rights was produced, some individual rights were enshrined in the original Constitution. For example, the individual's right to contract were protected. More specifically, the state was prevented from substantially impairing existing contracts through legislation. Enforceability of contracts was considered a foundation of trade and critical to economic prosperity, so the state was restricted from legislation that would void or impair existing contracts. In response to the emergency circumstances of the Great Depression, government legislation that affected existing contracts between debtors and creditors was not held to violate this constitutional provision. The original Constitution also protected individuals from the state imposing retroactive laws. If the act was not illegal when it was committed, then the state cannot declare it to be illegal by the subsequent legislation. It's unconstitutional for the state to criminalize actions that were legal when committed, to increase punishment of a crime or lower the bar on evidence necessary for the state to win a conviction. State legislation affects crimes committed after the legislation was enacted, not those committed before. The Constitution restricts the government from taking life, liberty, or property from an individual without following due process of law. Due process usually means notice and some form of hearing, but it also applies to the legislative process. Government is restricted from summarily taking, say, property from an individual without providing notice, a hearing, such as a presentation to an impartial judge, and following certain procedures, such as opportunities to appeal. However, if the government passes a bill in Congress to take property from all individuals, then due process has been provided in the form of valid legislation. This rule applies when the government takes an individual's life, his property, or his liberty. A taking of liberty rights obviously includes locking an individual in jail, but has been found to also include the taking of other rights provided under the Constitution, the Bill of Rights, and state law. The action of the government in taking must be deliberate. Negligence of the government does not qualify for procedural due process claims. Many cases involve the taking of property, and many of these involve the government taking from the individual something such as a job, a pension, or benefit. This qualifies for protections of procedural process where the property is actually owned by the individual before it's taken. A job that's guaranteed for life, such as university tenure, would qualify, but a job under an at-will employment contract would not qualify as a taking for due process purposes. What if the individual is denied access to the process of law as he or she is too poor to pay the court fees? Well, if what's being taken from the individual is a constitutional right, then the court fees will be waived or the fees paid by the government. Poor individuals, as well as the rich ones, are allowed constitutional rights. The government can take private property for public use, but it has to pay for it. A taking has occurred if the property is physically removed, but also applies to occupation or use of property even when carried out on a temporary basis. If the government takes private property, it has to pay just compensation. Just compensation is calculated as the fair market value at the time of the taking. It's important to distinguish a taking from a reduction in value. By taking someone's land to build a government building, just compensation must be paid. However, if the government builds a sewage plant on land adjoining an individual's house, the value of the house may be reduced, but this does not qualify as a taking. There may be a significant loss of value to the individual, but the property remains under the individual's ownership, and this does not qualify as a taking for constitutional purposes. A state is not allowed to discriminate against individuals from other states. Article 4 of the original Constitution declared that the citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. This applies to citizens, individuals, not corporations. The post-Civil War 14th Amendment declared, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." Although this appeared to be designed to impose the Bill of Rights on the states, it was restricted and rendered ineffective by the Supreme Court in the slaughterhouse cases in 1873. The case has challenged the state monopoly of slaughterhouses and butchery. The landmark ruling restricted privileges and immunities to cases involving the federal government. It could be used against state governments, but only by former slaves. It was 150 years before the Supreme Court decided to open the door to this clause being available for forcing states to provide civil rights to other citizens. Under the Due Process Clause, the state cannot deprive an individual of life, liberty, or property without due process of law. Liberty has been interpreted to include certain fundamental rights. Any substantive government interference in fundamental rights is subject to strict scrutiny by the courts. Fundamental rights include the right to marry, procreate, have an abortion until the fetus is viable, the right to vote, travel interstate, and enjoy equal protection of the laws. It's a fundamental right for an adult to refuse unwanted medical care, and to view obscene material in the privacy of his own home. Although government action to interfere with these rights would be struck down by the courts, the government is not obligated to finance these activities. The government cannot prevent individuals from watching pornographic videos in their homes, but the government does not have to pay for the videos or ensure that a ready supply is available to the public. There's no fundamental right to a job, no fundamental right to a home, no fundamental right to grow a beard, no fundamental right to sexual activity between consenting adults in the privacy of their own home, no fundamental right to assisted suicide. The list of fundamental rights is limited. Other rights are not considered fundamental, and government regulations affecting those rights are usually upheld, as they're only subject to the lowest level of scrutiny. Any rational basis for the government to set the law is sufficient for the courts to support the government's position. Although there's no constitutional provision on point here, the courts have consistently struck down laws that are vague or overbroad. On the principle that it's unfair to prosecute when the offence committed is not clearly specified, a law is vague if it's not understandable by a person of average intelligence. The danger is that unspecific, vague and overbroad laws can be interpreted by the police and government to pursue personal and other agendas. A loitering regulation forbidding an individual from being in a place with no apparent purpose was found void for vagueness and unenforceable. This principle is also sometimes used to strike down municipal bylaws that forbid explicit or objectionable content from being sold in a certain city. A law prohibiting the interruption of police officers in performance of duties was struck down as overbroad when applied to convict a man shouting at police for arresting his friend. States are forced to provide each person with equal protection of the law. An individual cannot be denied the legal protection enjoyed by all. Please refer to the separate slideshow on this topic.